Harlow Collinge was a healthy, happy and much loved when he was dropped off at your home by his mother on the 1st of March 2022. She'd been using your childminding services for some 6 weeks, but not without some concerns. You had been an Ofsted registered childminder for approximately 9 years and were aged 61 years old. You should have been a very safe pair of hands into which Gemma Collinge could entrust her child, but you were not. Within 2.5 hours of being dropped off by his mother, Harlow had sustained devastating injuries which caused him to go into cardiac arrest. He was taken to hospital but never regained consciousness. He'd suffered precisely the type of injuries that the treating doctors would expect to see in cases of non-accidental shaking injury. After consultation with his parents, whose agony can only be imagined, Harlow's intensive care was withdrawn and he was pronounced dead on the 5th of March. As they have movingly described, for his parents, siblings and grandparents, Harlow was a little treasure and his loss is a tragedy, the effects of which will never diminish. Nothing that can be said or done can erase what is a life sentence for them. The sentence that I will impose on you will come to an end. Theirs never will. At just after 1 o'clock that day, you called 999 and said that Harlow was not breathing and that you thought he was choking, having suffered a fit, and that he was not breathing. This was not truthful. He'd not choked. You had violently shaken him. Following instructions, you administered CPR. When the paramedics arrived, you said that he'd not choked, but in fact had finished his dinner, and the next minute he collapsed and that he'd been floppy, drowsy and unwell. You gave a different but equally untrue account over the phone to Harlow's mother and told her that he'd choked on pasta and stopped breathing, that you'd been trying to resuscitate him. Questioned by doctors who were struggling to reconcile what you were saying with Harlow's condition, you said that he'd not choked but had finished eating. When you picked him up from his high chair, he became stiff and stopped breathing. You then slapped him on the back several times and commenced CPR. When the police officers asked how many children you were looking after, you said it was 3, Harlow and 2 children aged 4. You knew that this was not an accurate account, as you were also looking after an 11-month-old child. By having 4 children under 5 and also having 2 children under 12 months, you were in breach of Ofsted rules. The medical picture began to emerge as tests progressed. Harlow had suffered serious and irreversible brain damage with numerous areas of bleeding, the significant effects of a lack of oxygen, and extensive swelling. You were arrested and interviewed. You denied having done anything to cause Harlow's injuries, but expert analysis was telling a very different story. The widespread brain damage must have been caused by a serious head injury, which led to cardiorespiratory arrest. The brain injuries were in keeping with severe acceleration-deceleration type injury, or as it is commonly known, a shaking type injury. Such shaking being outside the normal handling of a child and markedly excessive and inappropriate. There was also bleeding into the spinal column and bleeding into the nerve roots extending down the length of the spine, injuries commonly associated with vigorous shaking. Imaging revealed bleeding behind both his eyes. Again, this is typical of severe head injury caused by shaking. One finding of perimacular retinal folding was an indicator that the injuries were at the extreme end of what is usually seen in abusive head trauma. So the combination of injuries Harlow had sustained suggested forceful shaking and or shaking with impact. There's no evidence that Harlow had choked, and being slapped on the back would not have caused such injuries. However, as this evidence emerged, you still denied causing him any injury, a stance you were to maintain through to the morning of the trial. The experts also found other injuries to Harlow's ear and fractures to his ribs and sternum. But I cannot be sure when and how these injuries were caused, and I disregard them. During that first interview on the 22nd of March, you again failed to accurately disclose how many children you had been looking after. You were then interviewed for a second time after Harlow had died on the 15th of July 2022. This was after you had had time to reflect on what you had done. Yet again, you repeated that you were not responsible for Harlow's death and had not caused him any injuries. You specifically denied that you'd lost control and said that there had been no accident. Despite the overwhelming evidence against you, it was only on the morning of the trial when you admitted assaulting Harlow that morning by violently shaking him. In your basis of plea, you state that you were under enormous strain at the time, in regular pain with your hip, and shook Harlow in frustration. However, this explanation needs to be put in context. You told Ofsted in 2014, and stated later in the police interview, that there was nothing about your health that prevented you from safely caring for children that you minded. However, in February in 2018 and in 2022, you'd applied for benefit, personal independence payment. The picture painted in those applications was that you were very significantly disabled. In the 2018 application form, you stated you felt constantly drowsy and tired, that sometimes you could barely move or safely carry out daily living activities. You gave the impression that you barely went out. This was all repeated in your 2022 application just days before Harlow's death. In that application, you described overwhelming fatigue, having excruciating pain in your feet, that you needed help to go to the toilet, and that you could no longer cook or even cut up your own food. So others had to provide care for you. This description was a world away from you caring for children. You now say that at the time of Harlow's death, you were in regular pain with your hip. Only you know the full truth about your physical condition. But clearly you have not told the truth to a significant degree at some stage. It is not credible that you were as disabled as you claimed in your benefit applications. But your recent admission of pain and your medical notes, which refer to a range of conditions, including sciatica, heart failure, and joint pains, including in the hip, do show that you had significant physical issues which would have impacted on your ability to look after several small children at once, with the movement, lifting and carrying that entailed. You chose to work on despite your health issues. You also chose to breach Ofsted rules and to care for too many children. With the demands that they bring, the rules are there for good reason, to ensure the safety and welfare of children. You say that you were under considerable pressure financially. The way out of that was not to work when you were not fit to do so, or to take on the care of more children than you were supposed to. You brought any strain that you refer to on yourself, and in so doing, put Harlow at risk. I have no doubt that you snapped on the 1st of March 2022, in part due to the fact that you were not coping easily with the demands of caring for 4 children, 2 of them, as I have said, under 12 months. I'm sure that you found caring for Harlow and the other children difficult that morning. You say that Harlow was grisly. Well, babies and young children often are, and parents cope with this day in and day out. You were an experienced childminder holding yourself out as a specialist carer. There was nothing exceptional in Harlow's behaviour. Rather, it was the pressure and difficulties that you imposed on yourself that were the main cause of this terrible offence. Any frustration was self-imposed and not caused by unusual behaviour from this 10-month-old child. You lost your temper, and he was on the receiving end. There is a sentencing guideline which I am required by law to follow. It covers the offence of manslaughter, which may be committed in very many different ways. Here, the criminal act is one where a reasonable person would realise that there was a risk of at least some physical harm. I have to assess your culpability to arrive at the correct starting point for a sentence as set out within the guideline. In my judgment, you had high culpability. You shook a 10-month-old child so violently as to cause devastating injury. The magnitude of force required to cause injury in shaken baby syndrome has never been measured for obvious reason, and I recognise that it's difficult to quantify with confidence in any case. Although excessive and well beyond rough handling, it may not necessarily be severe. However, as a matter of common sense, Harlow was 10 months old and not, as sadly the courts are sometimes concerned with, a baby of merely weeks old, with a corresponding size difference and the necessary degree of force to cause these injuries. His death was caused in the course of an assault which carried an obvious high risk of death or really serious bodily injury. This is clear as an objective assessment, but I have no doubt that as an experienced childminder, you well knew this at the time. Given the injuries and the entirety of the medical evidence, I'm also sure that in the moment when you lost your temper, your intention was to cause harm just short of very serious harm. So it is clear to everyone, if your intention in that moment had been to cause very serious harm, then that would have amounted to murder and the sentence would have been very different. Also, you may have immediately regretted what you did, but that does not affect the fact that you had the intention. There are 2 Category B features as set out in the guideline, and I've considered whether Category A is appropriate. But having carefully considered matters, I am satisfied that your offence should be taken as within Category B and the range of 8 to 16 years. The starting point in the guideline is 12 years. However, a starting point is just that, and I have to consider where your offence should lie in the range and have regard to aggravating and mitigating factors. As for aggravating features, the first is that you were in a position of trust. Harlow's parents trusted you, a registered childminder, with his health and safety whilst they worked, something so many people have to do each day. Harlow was vulnerable given his age, but it is necessary to avoid what would be double counting, given that it was his vulnerability which gave rise to a need for care, which in turn led to you being in a position of trust. You were keen to persuade parents that you could be trusted and reassured them when they raise legitimate concerns about the standard of your childminding. The second aggravating feature is, as I've indicated, that you well knew that you were not as able to care for the children in your charge that day as you should have been. You had health issues and you were caring for too many young children in breach of the Ofsted rules. You chose to accept the children into your care so that you could make money, prioritising this over their welfare. As for mitigating features, I accept that the offence was not premeditated and you have no previous convictions. I also take into account the statements of some of the parents of the children you looked after and the contents of the references from your family and friends. I accept that in the past you have looked after some children very well, including ones with complex needs. Also, that for the great majority of your adult life, you've been a hard-working, productive member of society and a loving and supportive mother and grandmother. However, it's clear on the evidence that you've previously not been honest at times with Ofsted, the benefits agency, or parents, and what is set out in the references is in stark contrast to your behaviour before and, more importantly, on the 1st of March 2022. It is difficult to reconcile the suggestion that you are remorseful with your continued lying and refusal to accept what you did until the morning of the trial, when your lack of any sustainable defence must have been made clear to you by your experienced legal team. Up to that stage, nothing was admitted, and you must have appreciated the impact this prolonged uncertainty would have had on Harlow's parents. I'm not at all surprised that they were tormented each and every day by your refusal to be truthful about what happened to their son. Your basis of plea also does not show much self-reproach, rather much of it seeks to excuse your behaviour. In my judgment, after balancing out the aggravating and mitigating features, which requires more than a mechanistic approach, there must be a significant increase from the starting point in the guideline. You're entitled to a deduction on your sentence to reflect your guilty plea. You pleaded guilty after a jury panel was selected, but before it was sworn. A deduction of 10% is appropriate, given the guidance in the relevant guideline. I do not consider that you're dangerous, having regard to the criteria contained in the Criminal Justice Act 2003. You do not pose a significant risk to members of the public, including young children, of serious harm occasioned by a commission of further violent offences. You will serve 2/3 of the sentence before you're eligible for release on licence, but your release will not bring your sentence to an end, and if, after your release, you commit any further offence, then you may be ordered to return to custody to serve the balance of the original sentence together with any further sentence for the offence that you have committed. Credit must be given for time on remand. You will have spent 308 days in custody. If the calculation of the days served is proved to be incorrect, then this can be amended administratively. The surcharge applies and it should be drawn up in the appropriate amount. Two final matters. First, it is right that I recognise the hard work and professionalism of the police, the CPS and the legal team. This has been a very difficult and complex case, in no small part due to the lack of any admission by you of any fault before the morning of the trial. This meant that every angle and aspect had to be considered to ensure that justice was done. It's also right that I recognise the restraint and dignity displayed by Harlow's parents and his family throughout this trial and during today's hearing. They have suffered so much and have had to hear things which will always live with them. I can only hope that the conclusion of this case brings them some peace, however limited. Karen Foster, stand up. You are guilty of the manslaughter of a healthy 10-month-old boy by shaking him so violently as to cause devastating brain injury. You well knew that shaking a young child carried an obvious and high risk of death or really serious harm. And in the moment when you lost your temper, you intended to cause him only just short of really serious harm. I have no doubt that your significant health issues, combined with your deliberate breach of the rules as to the number of children that you could mind, meant that you were under very significant self-imposed strain, and this very significantly contributed to your loss of temper and the fatal violent shaking. Had Harlow's parents known of either of these features, they would never have left him in your care, and he would be alive today. They did not know, and the fault for that is entirely yours, not theirs. You chose to put financial gain before a young child's welfare. You breached trust, and you reacted with violence to his normal behaviour, causing his death. You then lied and only admitted what you'd done on the morning of the trial. I have not seen evidence of genuine remorse. For the manslaughter of Harlow Collinge, I sentence you to the shortest term which is commensurate with the seriousness of your offence, which, given the credit for your guilty plea, is 12 years and 7 months. You may go down.